I often forget. Okay, let's get going with this hearing tonight. Today is December 21st, almost 5:05, and we're getting started on the hearing regarding 96 Willow Road. And I'm going to call the meeting to order right now. I'd like to introduce the board members we have before us tonight. We have David Walsh, who is my co-chair and longtime member. He's here on the Zoom. Peter Barber, longtime member. And Max Casper, also a longtime member. And David McCool, longtime member now, because we have no alternates on tonight, all regular members. And the hearing process is going to be such that we will hear the applicant's petition, and then we will deliberate. But in between, we'll ask questions about their case. We'll give the public a chance to make comments, either for or against or in opposition. And then we'll bring any motions that we need to bring and make any findings we need to make and come to a decision, hopefully this evening. If not, we may have to continue, but I'm hoping that we can find a way to resolve things this evening. All right, so what I'd like to do next is to read to you the notice that was published in the Lynn item.
Jocelyn, can I interrupt you for a second? For
Sure.
technical issue, is there a volume button you can press on? The volume's kind of low for me. I'm not sure if anyone else is experiencing that.
Oh, I can't find.
No, I haven't had
Dave,
any-
you're on mute. Dave Walsh, you're on mute. I can see your mouth moving, but you're on mute.
Paul, I was going to say, if you use headphones, it works a lot better.
Okay, well, I didn't prepare for that, so for next meeting I will.
Can you hear me okay now, Paul? Should I speak a little louder
Yes,
for
that's
you?
better. That's yes, thank you.
All right. All right, so the notice that was published in the Lynn item on December 7th and 14th. A public hearing will be held by the Zoning Board of Appeals on Monday, December 21st, 2020, via remote technology, pursuant to Governor Baker's March 12th, 2020 order suspending certain provisions of the open meeting law, General Laws, Chapter 30A, Section 18, and the Governor's March 15, 2020 order imposing strict limitations on the number of persons that may gather in one place. This meeting of the Nahant Zoning Board of Appeals will be conducted via remote participation to the greatest extent possible. And then we publish the Zoom information. And the hearing tonight is a public hearing on the petition filed by Paul G. Smith, Esquire, and Judith Flaherty for the property located at 96 Willow Road, Nahant, for an appeal of determination of the Inspector of Buildings for the following. Appeal of Building Inspector allowing building permit R-18-00243 to be amended and the issuance and validity of the amended permit. Again, this ran on December 7th and December 14th. Okay, so we're ready to get started. And if the petitioner would like to begin their case, let's get started.
Thank you, Madam Chair. This is Attorney Dennis Murphy, and I represent Attorney Smith and the Flahertys. I submitted a letter this morning, and I just wanted to be sure everyone received a copy of it.
Yes.
Okay, so
Received by Kim Campo, and she sent everybody a copy.
okay, thank you. I also copied counsel, and my presentation tonight is going to follow basically the form of the letter. It's been a year since I was before this board, and we were in person in Nahant the last time, and I think just a brief recap of the history without getting too deep into it would be helpful. So there was a request for enforcement that you considered a year ago, and that was decided in July of 2019. And in your decision from February of this year, you upheld the building inspector's determination that as of July 2019, there had not been construction beyond the limit in the building permit. A year later, or almost a year later, a second request for enforcement was made about the same permit, which is the only permit that's ever been issued for this property for the current work. And it asked to examine whether the work completed up to that day, which I believe was July 1st, 2000, a year after the prior determination, whether that exceeded the amount of the building permit. So the things that were in common were the same property, the same permit, the same amount, but two very different time periods. One up until July 9th, 2019, and the second one, because your decision had said as of July 19th, 2019, as of July 9th, 2019, it hadn't exceeded. The question was asked as of July 1st, 2020, whether it had been exceeded. Now, I did not get a chance to address the board when it considered this issue, so I would like to start by arguing that it's not repetitive and therefore should be considered. And the first point I'd like to make is that this is a different request. It's a specific material change from the prior request. So an example of a repetitive petition is when somebody asks for exactly the same thing a second time. And generally, you're subject to a 2-year bar under zoning, whether it's a special permit or a variance. But this is not that. This is an appeal, and it's an appeal from a different request for enforcement. So each time a request was made, the building inspector didn't say, I'm going to deny your enforcement because it's repetitive. Each time he issued a different letter. Once it was dated July 9th, 2019. You affirm that based on the finding at the time. And then the request was made for the additional subsequent time period. And the zoning enforcement officer gave a different answer. He actually gave two letters, both of which I've previously submitted. One to acknowledge receipt of the request, and the second one to essentially deny it, but say everything you say is accurate. It's just moot because we've got an amended building permit. So the point I'd like to make is that this is not repetitive because it is a specific material change. There are two different requests for permits for two different time periods, and therefore it shouldn't be barred as repetitive. The second point I'd like to make on that issue is that if there had been a request for enforcement and it were appealed, and you denied the appeal, and then you got another appeal from the same request, that might be an example of a repetitive appeal. But that's not this case, and I wasn't at the September 15th meeting when this was discussed, and I don't know if that was a clear understanding that the board had. So that's why I wanted to sort of clarify my understanding of events and the two different requests for enforcement, as well as the two different appeals, both of which were about a year apart. The second point that I think is worth addressing on that issue is that I think the board has an opportunity this evening to kind of cure what I see as two possible missteps procedurally. And the first is, as I argued in my letter, that the statute requires notice and a hearing, and we have it now, but I wasn't able to be present because I didn't know about the September 15th meeting. And one way we might get around that problem is by at least allowing me to make the argument about it not being a repetitive petition. The second kind of infirmity or potential infirmity is about the notice for tonight's meeting, which makes no reference to anything I've mentioned so far. It doesn't include the request for enforcement or repetitive petition or anything about that. And, unfortunately, I had notice of it. I'm here, but anybody else who may have wished to attend, I don't know what they knew and how they might know to attend the meeting. So what I'm suggesting is the board has a chance to kill two birds with one stone by, you don't necessarily have to decide tonight that you want to reverse your position about whether it's repetitive. You could simply decide that it's worth hearing. And if you do, put it on and we'll do this.
Murphy, can I interrupt you for a second, please? Because
Sure.
we have not prevented you from making this argument. You're making the argument now. Make any argument that you like. We're open to hearing whatever you have to say. Okay, so
I
no one's
appreciate
stopping
that.
you from making this argument.
Yes, no, and I appreciate that, Madam Chair. And again, I was just speaking to the board's opportunity tonight to address what I saw as procedural infirmities that I actually tried to work out in advance. There's a lot of, in this case, where the lawyers disagree, but even Attorney Primison and I agree about these kind of procedural defects. And we've both called them to the attention of town council. And I would like, the board now has an opportunity to cure them. Like I said, kill two birds with one stone.
And as we said, you're welcome to speak about whatever you like. So just go on with your argument. Good to go.
Okay, thank you very much. So on the point about the request for enforcement, they shouldn't be barred as, this appeal should not be barred as a repetitive petition, because there's only been one appeal from the building inspector's determination. There was a prior proceeding, a different request for enforcement, a different answer, and we appealed that just once, and the board decided at the time that the building permit had not been exceeded. Since that time, my clients live right next door. They know that additional work happened at the property. Attorney Primison knows that the Rizzos have done additional work under that permit. The question is it beyond the limit of the permit? That was the question in the request for enforcement. The last time I believe I appeared before this board, I pulled out a letter tonight from my file that's from a Mark Verrett, a contractor, Fine Home Building. This is signed December 1st, 2019, and it says the cost for the 96 Willow Road is $146,100. Now, my recollection is that number was incorporated into this board's decision from February 28th, 2020. And so I don't think you need expert testimony or a whole lot of explanation to say 146,000 based on Mr. Verrett's signed letter is greater than 55,000, the amount in the permit. So for that reason, I think if you determine that it's not repetitive, then hopefully the remedy is that the original request for enforcement was in fact valid, and it should have been decided that that building permit, the work had exceeded the amount. Now, the question then becomes what to do about it. One of the things that I think everybody on this in this meeting knows is, at some point this has to end, and I have no interest in seeing it prolonged. And I think the question of the remedy is what the hangup is. But before we ever get there, you first have to decide, each of the little steps along the way. And the first one is on this request for enforcement about the value of the work being beyond the building permit. So let me pause there, because the second part of my argument has to do with the amendment to the building permit, and it may make sense, subject to the chair's prerogative, to deal with these issues one at a time, or whether you'd like to deal with them together.
Would you please you can continue with your argument, and let's have your whole presentation so we can move forward.
Okay, I'll take that to mean that I'll address the other issue about the amended building permit. And thank you for the opportunity to do that. So I laid out 3 reasons in my letter, and I think the most important thing, though, is really just a dose of common sense. We who are the lawyers on this call all appeared in front of at least 2 different judges since the last time I presented to the board. And I can tell you, I don't want to go in front of another judge with the story that we had to try to explain the last time. And what I mean by that is, part of the reason we've gotten into this situation is the first decision from the board was vacated. It was then amended and appealed and moved or transferred to a different court.
When did that happen?
And the issue with amending a building permit while it's in front of a judge, I don't think any of us want to be in front of the judge and say, Judge, what you've just spent your time trying to figure out is now moot because the building inspector has gone ahead and amended the building permit. And so there are legal reasons, and I'm happy to get in more detail from what I stated in my letter. The first legal reason is, under the building code, any power a building official has to modify, and by the way, that's not an express power. There is nothing in the building code that says the word amend a building permit. It is thought that because building officials have authority under the building code to grant modifications, that same authority would allow an amendment to a building permit. The problem is those kinds of amendments are not allowed where the property is in a flood hazard area or coastal dune. I cited those sections. I have them here. You can look them up. They're pretty self-explanatory. So I don't think a building permit legally could have been issued in an amended building permit in a flood hazard area under the state building code. The second reason is the one I alluded to that I call common sense, but it comes out of the statutory scheme in 40A. Under Chapter 40A, the building official is the zoning code enforcement officer. And under sections 7 and 8, he or she has all kinds of powers and duties and is answerable to this board. That's why it's called the Board of Appeals, that if some member of the public doesn't agree with the zoning or building official, they can appeal to this board under section 15. Further, if there's still further appeal, that can be brought to court under section 17. There's no provision anywhere that a building inspector whose permit or decision is on appeal to your board or to court can then cause an amendment to the permit to moot or solve the problem. And that's exactly what I believe is going on here. The third reason that I think it's legally not feasible to amend this building permit is because you needed a special permit before this building permit could be issued. In my view, you actually needed two. I won't belabor the first one. You heard my argument a year ago that because it's a non-conforming undersized lot, it required a special permit. Again, I'm not going to belabor that. I just mention it. I know the board's decision on that issue. But wholly apart from a section 6 special permit, a separate special permit is required to do any new construction or substantial improvement in the floodplain district. And substantial improvement is anything that's 50% or more of the market value of the structure. So under the Nahant bylaw, a special permit was required before any building permit could be issued. And that's how these work. You can't have a building permit and then go back and request a special permit. You have to have the special permit first. And for that reason, I don't think that this particular building permit could be amended. And I'll stop there and happy to entertain any further questions from the board or anybody else. Thank you, Madam Chair.
Thank you. Okay, so at this point in time, I'm speaking to the other members of the board, and that is, would we like to hear, I think that, why don't we hear both sides at this point in time? I think Attorney Primuson is here, or Mr.
Sorry, Madam Chair, I thought this Attorney Smith, I'd like to add a couple items, if you wouldn't mind.
Jocelyn, can I ask a question to the attorney that just presented first, just before it gets too far past it?
Max, go ahead. Question.
Just that last point he just made about the zoning bylaw requiring a special permit for a substantial improvement in the floodplain. Can you just give us a reference on the zoning bylaw for the section that you're referencing there?
Yes, Mr. Casper, it's 10.5, and I'd be happy to read the language if you want. I have it in front of me.
No, you don't have to read it. I just want to look it up. Thank you.
Sure, 10.5.
Okay, so at this point in time, typically what we do is we ask any questions that we have of the person who did the presentation. Do any members have any questions for Attorney Murphy?
So, Jocelyn, I'm sorry, Paul Smith, I'd like to add something to the plaintiff's argument.
Certainly. Certainly, go ahead.
Okay. So I want to start at the back end here. In order to amend a building permit, any building permit, there's a condition precedent, and that means you have to have a valid building permit to amend. So in this instance, on July 3rd, when my request for enforcement was filed, Bill Inspector found that everything stated in that building permit request for enforcement was correct. And those items were pretty lengthy, but reading just a couple of lines, that this complete gutting and remodeling are work grossly in excess of that which was allowed by the building permit granted on December 11th, 2018. Another line, work in excess of the issued building permit violates zoning bylaw, section 9.2, as well as the building permit itself. And also, it exceeds the 55,000 amount permitted and requires you to rescind or revoke that building permit. So as of the day that that was filed, Mr. Wilson agrees those items are correct. He doesn't have the ability to make this determination on that request for enforcement subject to future activities, something that happens 2 weeks later, 5 days later, 8 days later, a month later, and say, oh no, everything you're right, but now we've changed it. We've now moved the goalpost, so to speak. So the condition precedent is not there. There is not a valid building permit to be amended. Now, let's just be, put everything on the table. Everyone knows from the outset that the project was vastly understated. Everybody knows that. And the reason it was understated was so that it could comply with the 50% rule. And everyone, Mr. Rizzo included, held steadfast it was 55,000, even though I had an expert who signed an affidavit under the penalties of perjury that it was 330,000, and he provided detailed documentation, invoices, statements, sizes of windows, all of the things that were required by FEMA, rubbish collection, disposal, the siding, the cost, the labor, the increased percentage that's supposed to be put on there by the state labor code. And that's what you had in your possession. You had no documentation whatsoever till December 5th. And on December 5th, you got a letter that says, yeah, it's 146.1, but no backup documentation, which clearly would have shown you that this was well in excess of the 55,000. So at that December 5th, the continued hearing, you had in your possession, right in front of you, statements that it was from Mr. Rizzo and his contractor that was 146, but you chose to ignore that. And then instead, what you did is you said, okay, I'm going to set the artificial date as July 9th, the date of Wayne's letter. So everyone knows and agrees that the project was at least 146,000. But you folks now are jumping through hoops and wrapping yourself around like a pretzel to ignore that fact, to not allow that to be heard. You hold I'm going to call it a secret meeting. You didn't give notice. I mean, we're supposed to be fair, impartial, honest, do the right thing, but you have a secret meeting so that you don't allow the parties to present their case. And then, Madam Chair, you go forward and file the minutes of that meeting with the town clerk before they were approved by the board. I don't know to what end, but I'm sure that you were probably directed to do so. Additionally, at that meeting, that secret meeting, your vote was a compound vote. I'm trying to read it here. I think it's in something you have. You have it, but it was that we find. Oh, here you go. But constitutes a repetitive petition and is to be transferred to the planning board for a hearing on this issue. So that's what was presented for a vote. And that was on September 15th. And then you filed those minutes on September 28th without them being approved. And then on October 1st, 2 weeks later, Mr. Script comes forward and says, hey, guys, due to my oversight, that motion was in error. The planning board has no role in this process, so we're not going to, that's the quote, and then it goes on to say that we're not going to refer it to the planning board. But that wasn't what the vote is. The vote that maybe folks on your board would have voted differently had the actual vote that was supposed to be in front of them because referring to the planning board on this issue for a hearing on this issue suggests that this is going to be heard in a public meeting, but it wasn't. And so 2 weeks later, Mr. Script comes in and says, yeah, no, only half of that motion is good, but it's still valid. I suggest to this board that is not the case. It is not valid. It is totally inappropriate to take that as an approved motion when in fact it's changed 2 weeks later. I would be curious to understand how the September 15th meeting came about. Mr. Wilson didn't make any objection to it in his response to request for enforcement. It was not brought up by Mr. Rizzo or his counsel. So my suggestion is that town council directed you to do so. And I submit that, you know, once we start making these mistakes and then we keep on compounding them, it makes it more difficult to extricate ourselves from it. Okay. One more thing that's back to the amending of a permit. You folks on December 5th were discussing the two issues about being in excess of the building permit and then also the 50% rule. I think it was grossly inappropriate that you utilize the 146 for one of the subjects, but not the other, be that as it may. But then you went on to have a discussion, and the question was asked, and Max, about because he is the bill inspector in Swampscott, whether he had, about amending permits. And I have the tape here with this process into the phone from a cell phone. I'm not sure it's going to be heard, but I'm going to play it for you now. But what you'll be hearing is Max saying, well, you can amend permits, but we wouldn't do it in this instance as we're so bogged down. And you, Jocelyn, said, yes, of course. And Dave Walsh, you add in, yes, of course, as well. So I'll try that for you. It's just to remind you folks of your prior comments. Hold on a second, please. Yeah, wouldn't you know? Okay, so I'm doing this through the speaker and hope this comes out.
55,000, and you overspent on it, then you ought to be going further. No, you can amend it. You can amend it. Adjust the price. But you know, this is something we have all down on this, wouldn't amend at this point. Right. Right, exactly. So
I don't know if any of you got that, did you? Madam Chair?
Not really, no. But if it's something that's already on a tape from a prior hearing,
Yes.
then you would have, no need to try and make a new record because you could reach back to that tape if you wanted to play it for some reason. But
I was playing it for the purposes tonight. You guys are going to have a discussion about the validity of amending a permit, and you're already on record about talking about this particular instance. And you yourself, Madam Chair, says no, you wouldn't. I agree, I wouldn't do it at this point. And two of your other board members as well. So I'd be curious to see why you would have a change of mind.
Okay, go ahead. Continue.
All right, that's all I have for now, Madam Chair, but I would, actually, one more thing. I want to reiterate for the record that all of the issues and complaints and concerns that the plaintiffs had against the one and only original permit, that if this board should tonight suggest that the amended permit is appropriate and valid, that we reiterate all of those same complaints against that were an original permit against this new amended permit. And they are voluminous. And one more thing, Madam Chair. what's
Yeah.
been going on here is the moving of the goalposts, the hiding of the P. We don't want to hear this because it's not good for our side, type of thing.
Fine.
This isn't appropriate for a town board like this. But what it's ultimately doing, it's victimizing and hurting lots of folks. It's hurting us, the abutters, and it's hurting Mr. Rizzo. He's been led down a path that takes too many wide twists and turns, and it's going to be a lengthy and costly approach. Should you amend this permit, this is just going to be an amended complaint. All those same issues are there, and we would just go on and on. Again, Attorney Murphy struck on it. If you're in front of a judge and you have a case going, and then at the moment the bill inspector and the applicant don't like the way things are going, they say, "Oh, geez, let's hatch a plan. Let's hatch a plan. Let's amend that permit." And by the way, that's what happened here. After you got the request for enforcement, there was let's powwow and let's hatch a plan to see how we can subvert it. But you hatch a plan, and it takes it out of the hands of that judge. And there's nothing to, if you agree that that's okay, there is nothing to stop a building inspector to keep on doing that whenever he sees things going south for him in court. So this is adding on to Attorney Murphy's, but I think that's wholly inappropriate. And I'd ask the opportunity if further comment as time goes on. Thank you.
Okay.
Madam Chair.
Do any of the members have any questions for the applicant or for his attorney before we proceed?
Madam Chair, can you
Yes,
hear
sir.
me?
Yes, I can.
This
Yes.
is Wayne.
Mr. Wilson? Hi.
Can I speak to that statement that Mr. Smith just made?
We were going to hear the other side right now and then come back to that.
Speak to
If you want
something,
to speak now, go ahead. That's fine. Go ahead.
speak to one particular item that he just alluded to about all this collusion that he's totally dreaming up. One, my office didn't know that anything was in front of any judge. We're not aware of who's in front of who and when. So for him to say that someone hatched a plan to screw up his case, is totally ridiculous and absurd. The plan that was amended or changed was changed specifically at his request. He was the one that demanded it comply with the 50% rule. The homeowner admitted that he was going to violate the 50% rule. And at a meeting that everyone in this meeting was present at, he said he was going to come back with a new plan to come into compliance with the 50% rule. Everyone knows that, including Mr. Smith. And when he came to my office with that new plan that complied with the 50% rule and a new number, which was an amended estimate for the construction costs, then the building permit was amended and as such. And there was no discussion at any meeting that I was present at about whether or not a building permit could or could not be amended. That what happens to a building permit is my prerogative. I could have issued him a new permit but I didn't. I just amended the old one. I don't see the difference. There's no difference between an amended permit and a new permit. So I don't understand. To make the point that somehow somebody was doing something on purpose just to screw up some court case is absolutely ridiculous.
Thank you.
I could do a brief response, Madam Chair.
No, please not right now. Let's move on. Mr. Permison, did you have anything you'd like to say on behalf of Mr. Rizzo and 96 Willow Road?
Yes, I do.
Excuse me, Madam Chair.
Yes?
May I address?
Who else is speaking? I can't. You're in a butter?
Yes, I am.
Okay, we're not quite done with the presentation yet.
Hello, can you hear me?
Done. As soon as we're finished with the presentation, we're going to ask for anyone who would like to speak in favor or against, okay? So hang on.
Thank you.
Mr. Primerson?
I can't hear what you're saying. So
Okay, would you like to proceed with your position?
Okay.
Go ahead, sir.
generally, Mr. Smith's position seems to be that a homeowner who wants to comply in full with the zoning bylaw and the FEMA regulations because his home is in a flood zone can't do that. Can't be done because he objects to it. Regardless of the fact that the building inspector determines that there's nothing wrong with his application and he's entitled as a matter of right to build what he's.
Mr. Primison, I think he froze.
I shut him off.
He got involved in respect to his original project. And this board ruled, in essence, to the effect that he probably wasn't going to comply. So he endeavored to fully comply. He said, I will change my plans and I'll fully comply. And he consulted with the building inspector on what might be, this is my understanding, on what might his
Mr. Primuson, you've been freezing, so you might want to
who
try
then said
calling
new.
in.
Yeah,
Comply.
Mr. Primison, you keep freezing up. I'm wondering if you, and I'm hoping you can hear me better than you can hear the chair, but you may want to try dialing in on a phone, just because you keep freezing up and we're getting probably every third or fourth word.
I don't know how to do that. I'm on a phone.
Oh,
Well, if you look at the invitation, there's a list of telephone numbers. Any one of them you can call and you
Yeah.
will show up.
yeah. Put in your passcode. You won't show up on video, but I mean, unless you want to show something.
Well, I don't want to show something.
Okay.
And if you'll give me the phone in information, I will leave the meeting this way and call in.
Okay. You can call in the number 1-646-558-8656.
May I read that back to you, Madam Chairman?
Yes.
1-646-558-8656.
Yes, sir.
Okay.
You need a passcode. Passcode.
The
I need a passcode.
Yeah.
Usually you have to put that in, yes. The passcode is 246714.
Okay. I'll make an effort to do that right now.
Okay, thank you. We'll place on hold for a minute while he's doing that.
I apologize for the delay. Am I now being heard?
Yes.
Thank you.
Thank you.
And thank you for waiting. So it's generally my client's position that he's trying to comply with the zoning bylaw and the FEMA regulations. That's the amended building permit. It's my understanding that the building inspector consulted in connection, prior to approving this or issuing the amended permit with a gentleman from the Massachusetts Department of Conservation and Recreation, and Mr. Wilson then satisfied himself as to what was required by the FEMA regulations prior to issuing this amended building permit. Let me try to address Mr. Murphy's letter briefly. I disagree with him, and I disagree somewhat with the town council, my brother, Attorney Script, that I think that Mr. Smith's appeal may very well have been repetitive, and that when a potentially repetitive petition is submitted to the board, the board has no jurisdiction to hear that appeal or petition unless and until the planning board first determines that it's materially different from any prior appeal that was acted negatively. And that's in fact what the board apparently voted to do. And then where I disagree with Mr. Script is when he said, no, that's not how it's supposed to happen. It's my client's position, it's my position that that's exactly how it's supposed to happen. That the zoning board does not have jurisdiction to make a determination that a subsequent petition is not barred by Chapter 48, Section 16, unless and until the planning board makes that decision and then consents, if it agrees that the appeal is not repetitive, that it is about something different, it then consents to the ZBA holding its hearing, and that was not done in this case. So, number one, I challenge the authority of the board, the jurisdiction of the board, to hear part one, I'm calling it, of Mr. Smith's appeal. And then I have a question of the board that I don't expect a direct answer to, but I ask you to consider in your deliberations as to whether or not that part one now is in front of the board tonight. I think there's some confusion about that. And my understanding is that the notice doesn't indicate that that issue is before the board. In addition to the fact that the notice, as I understand it, says that the meeting is on Wednesday, December 21st. We all know that today's December 21st, and we also know that it's not Wednesday. So I'm not sure what the effect of that discrepancy is on the validity of the meeting, but I ask the board to consider it. On the authority to amend the building permit, I suggest to this board that a building inspector has broad powers when it comes to the issuance or denial of a building permit. And he's guided by the zoning bylaw and by the state building code. And the building code in this instance adopts the FEMA regulations because of the location of the project in a flood zone. It's inherent, I suggest, in the authority of the building inspector to amend a previously issued building permit. And as he mentioned a few minutes ago, to rule otherwise in this case is simply a matter of form over substance. In fact, new plans were submitted to the building inspector. Those plans were compliant, or an effort to be compliant, with the FEMA regulations and the, quote, 50% rule. The 50% rule, may I comment, doesn't prevent an owner of property, which is in a flood zone, from making substantial improvements. It prevents a substantial improvement, which is defined by 50% of the value of the structure prior to the improvement. That does not, you cannot issue a building permit under those circumstances. You need a special permit. But if you're trying to comply fully, there's nothing in the law that says a homeowner can't comply. If he has a property that's in the flood zone, he should comply if he wants to make a substantial improvement or build. And that's what my client is attempting to do, comply. So when the building inspector says that he consulted with other parties prior to issuing the building permit, I think we should uphold his decision, because he's the one who knows what the plans are, what the plans say, and whether or not those plans put forth a project that complies with all the regulations that it needs to do. Nobody, neither Mr. Smith nor counsel for Mr. Smith and the Flahertys have suggested otherwise. As the building inspector said, this is a matter of form over substance. He paid the additional fee, my client paid the additional fee that was calculated by the building inspector, which would have been, in essence, the same as applying for a new permit. And he could have applied for a new permit, but the building inspector, in his discretion, and I suggest to you that it's inherent in his powers as building inspector to do this, he says, no, I'll look at this amended situation. I'll figure out how much the fee is. I'll see that you pay the fee before issuing a building permit. And that's what took place. I have nothing further to add to the board, and just ask you to listen to the building inspector, who I assume is going and hope is going to speak against this appeal, and have him explain to you exactly what he did and why he did it and why the project complies with the regulations. Thank you.
Okay, thank you. Okay, so fellow board members, we can now go into asking, are there any questions of Mr. Attorney Primerson from the board members? Peter, you're on mute.
Just a quick question. He said you said he disagrees with Attorney Scripp on one point. Could you just clarify what? I didn't hear you disagree with him on anything.
I agreed with him when he initially advised you that the appeal may be repetitive and that it should be referred to the planning board. When he changed his mind, or when he came to a different opinion and so advised you, that's where I disagree with him.
You're saying it should have gone to the planning board?
I am saying that, yes.
Okay, okay.
Because what I'm saying is that if the appeal is not materially different, and it's within 2 years, then the board is prohibited by 48 section 16 from hearing the appeal. But the board doesn't make that decision initially. The planning board, after a full hearing with notice to all the parties interested, makes a determination as to whether or not it's different and in a material way, and therefore not repetitive. So when the planning board is deprived of that opportunity, the statute says they have to give their consent to the ZBA to hold the hearing. Our position is that it should have gone to the planning board. They should have heard what Mr. Smith's appeal was about and how it was different. And if they agreed with him, they could grant their consent to the ZBA holding this hearing tonight, which they didn't do. That's my position.
Okay, can I ask a question of Attorney Script? Can you tell us why it is you felt that the planning board did not have to hear that?
Oh, I'd be happy to. First of all, I need to point out, this is not on the agenda tonight. This is not part of your deliberations. The decision has already been decided. The plaintiffs or the complainants have they've made their record. So when it does go to appeal, they can argue that. But this is not before you guys today. This is not something we should be discussing in a deliberative form.
We're not necessarily, we're asking questions right now.
Well, they're saying that you're going down that road. But in any case, that's fine. I'm happy to explain. And I think Webb has a misunderstanding of our position. The way the bylaw reads, which is consistent with the statute, says if the Board of Appeals has received a petition and they suspect it's repetitive, they then have a meeting to determine whether it's repetitive. That's number one. Then they have to go further and say, okay, it's repetitive. And then and there, it's prohibited unless there are specific and material changes and conditions. And that's where the Board of Appeals, that you guys would come in and say, yes, there were specific and material changes. Yes, it is repetitive, but there are specific and material changes in the conditions. That is what you guys would send to the planning board for, as Webb mentioned, consent. And then it comes, and assuming the planning board consents, then it goes back to the Board of Appeals for an actual hearing.
I see.
So in this particular case, what the ZBA held was, yes, we believe it's repetitive and we do not see material and specific changes. There are changes in conditions. So it ends right there. So you might say, well, geez, that doesn't sound very fair. What about the other parties? Well, the fact is, the whole idea behind repetitive petitions is to avoid hearing after hearing after hearing, because it takes a lot for the attorneys to prepare and the witnesses to prepare for hearings. It's a big deal, to be quite frank. So what the law says is, hold on, we're going to put an end to this. If it's repetitive, then it doesn't go any further than the Board of Appeals or whatever board's appropriate at that moment hearing that particular petition, unless there's specific and material changes. There were no changes in conditions, and that didn't exist here. So, and my mistake was not ending it right. I advise you guys to end it right there. So the planning board could weigh in, of course they can, but at that point, without the foundation set by the Board of Appeals, the Zoning Board of Appeals, nothing happens from there. And I know the complainant keeps talking about the secret meeting, and it's laughable. The meeting was posted as any other open meeting would be. In fact, it was posted in 2 times the amount of time any open meeting has to be posted. So it's quite frankly, it's baffling how folks tend to use this word in connection with that meeting, but everyone has their positions.
Thank you for answering that question, Attorney Script. Okay, we'd like to move forward now. Do any other members have any questions?
Yes. So earlier, Attorney Murphy had said, I think when referring to the bylaws and the building code about the ability to amend a permit. There's nothing in the building code or I think bylaws to amend a permit. Is that what you said, Mr. Murphy? Or?
Yes, that's correct. That the only thing in the state building code that could be construed as authority for amendments to a building permit is the building officials inherent authority to modify the building code. So a building official can grant modifications for individual cases, provided they find that the special individual reason makes the strict letter of the building code impractical, and the modification is in compliance with the intent and purpose of the building code. But the problem is that's not available because the very next section says the building official shall not grant modifications to any provision related to the flood hazard area, which is what we're dealing with here.
Okay, so aside from that, and this is going out, this question is, I started with Attorney Murphy. I want to add the other attorneys in. Is there anywhere in the building code or our bylaws where it says a building inspector can't amend a building permit?
Thank you for that question. No, there is not that I'm aware of.
So a building inspector has the right to amend a building permit when he feels, I mean, he's the authority having jurisdiction. I'm bringing out my past electricians. I was a licensed electrician until a few years ago. And there's always the authority having jurisdiction. Our building inspector is the authority having jurisdiction. Therefore, he's able to, there's nothing that says he can't. He's able to amend and Max, I'm going to ask you because you're also a building inspector. Is there anything that says that Wayne cannot amend a building permit?
Could I speak to address that question?
Sure.
This is Attorney Premison. My understanding is that this happens all the time. Let me take an example of an electrician who is doing work pursuant to a building permit and decides, in conjunction with the homeowner, that some additional work would be nice or appropriate. And it exceeds the scope of the original permit. You're telling me that the building inspector can't amend the permit as long as the work is being done in conformance with the code, to add additional outlets, to change the lighting scheme, to, I don't know. I don't know enough about being an electrician to know what those kinds of things are.
And I guess that's my point, is that happens all the time.
Doesn't this happen all the time? Doesn't it happen all the time?
Yes, it does. I can tell you from,
that's what I thought.
At least from my experience, that, I mean, not that I pulled that many permits and did that much, work under my own license, but in the years I worked for different companies, we would go in and hang a ceiling fan in the bedrooms, and they'd say, hey, we might want to put air conditioning. Could you add a couple of outlets? Yep, we got to go back and amend the permit.
Okay, so Peter, and then what I'd like to do then is I'd like to ask that question to Mr. Wilson, who is here from the building inspector of town of Nahant. Mr. Wilson, in response to, can you respond to Attorney Murphy's claim that you cannot amend a building permit pursuant to the building code in a flood zone?
All right, so he's
referring to modification section of the code.
He's misreading what that sentence says. What that sentence says is that I am not allowed to modify the rules relative to construction in a flood zone. In other words, I can't simply, like the argument that's been made from the beginning, is I can't allow someone to build a house if the at the height less than what is required in that particular zone. It's not a matter of, it has nothing to do with the actual building permit. It references to you can't change the rule book.
Okay, are you referring to that section R322.1.4?
I'm not. I don't have it in front of me, so I'm not. I can't.
No, Madam. I think he's referring to 780 CMR 104.10.1, which is in Dennis's letter.
Okay. So you're saying that he's basically misread that section and that you're,
Says that I can't change the rule book,
okay.
which we're not. This is not what we're doing. It's using one rule to kind of cover a different circumstance, and that's not what it says.
Okay.
Am I coming across? I don't know. I'm sure if that explains it.
So you're basically saying what they're pointing out in this letter, but they're saying that you would need, you can't basically issue a permit without a variance. But what you're saying, that's not what it means. It means that you can't allow a variance if the variance is outside the FEMA requirements.
I'm not sure the use of the word variance is the right word to use here, but essentially.
Well, I'm taking it from his letter, without granting of a variance to such provisions. I mean, essentially what you're saying is you can grant the permit, but you have to, when it comes to a flood hazard, you have to fully comply with FEMA regulations or the building code that says this is a flood hazard and you have to build to this. That's what this is saying.
What that means, right?
Okay.
That's to amend the building permit isn't amending the rules. It's just amending what was written on the permit.
Right.
Okay.
And again, the amended permit is no different than if I issued a completely separate new permit. It doesn't really matter from a building permit standpoint, whether I amended the existing permit or issued a whole new one. I could have done that. I mean, but it didn't seem like it made sense to do that. So we just.
Wilson, do you want to tell us what your thoughts are on all of this right now before we move into any further questions?
I'm not sure my thoughts
on position. What are your position here? You issued an amended permit.
All right. Well, let's start at the beginning. The homeowner attempted to skirt the 50% rule. He admitted that in a hearing in October, if I remember correctly. Well, I don't remember the exact date, but he admitted that he was going to go over the 50% rule. And he said, okay, you got me. I'll come into compliance. I'm going to come back with another set of plans that are going to make my house comply. What else can I do? Yeah, you caught me. And he did. He came back to me with a new set of plans that show compliance with the floodplain rules relative to his house, which essentially all it really amounted to was that he has to fill in his basement and make flood openings so that the water can flow through. That's essentially the only material change to his plan is that he can't have a basement anymore. His first floor elevation is above flood zone. So he didn't have to raise up the whole house. Didn't do anything special. He's got an existing foundation there. He needs to fill his basement and cut openings in it in order for the water to flow through. That's the modification, essentially. So he increased the price. He increased the cost estimate of his permit with his new plan, paid the additional fee, and we amended the permit and let it go. I never took his permit away from him, so I didn't have to issue anything. It was under a voluntary hold at that meeting from October. So, and then so to come back and just add another name, the request for enforcement was pretty much a carbon copy of his original request for enforcement. Only he just added his name to it. Instead of just being for him, he added Mrs. Flaherty's name on it and him as the attorney. And I think I don't have all the stuff in front of me at the moment, but I essentially said, well, this is exactly the same material we already covered. So why is this in front of me? And of course, anything I've said to Mr. Smith since this project started has either been, there's always something wrong with it. So for him, and I don't understand why he seems to think that there's some big conspiracy, to beat him up. I mean, and I understand his point of view at all, to be honest with you, but that's beside the point.
It's okay, but you don't need, it says, okay, a question to you, one more question to you, if I may, is that you're saying you're issued the permit, and is it your position that this property is going to be in compliance with the flood
Absolutely.
regulations?
It absolutely will be.
Okay.
Jocelyn?
Now, go ahead, Peter.
I just have a comment. I don't quite think that Mr. Wilson got it right when he said that there was like an aha moment at one of the hearings. And hear me out and correct me if I'm wrong, but at one point, Mr. Rizzo determined that his new estimate, because he wanted to put in a heating system and air conditioning and stuff, his new estimate was going to be 146,000, and change. And he attempted to get an appraisal and say that his house was worth more than what we use as our general appraisal value. So it wasn't like there was an aha moment that all of a sudden Mr. Rizzo admitted that he was going over. It was more that he wanted to add some things. He knew he was going to go over, and he attempted to try and increase the value by going with an appraiser, which is not the way we normally handle things. Am I wrong in saying this?
No, that sounds pretty accurate, Peter.
Thank you. I just don't want to, as it is,
Well,
there's
again,
this
fine doing that.
conspiracy theory out there, and I want to make sure that, that we get this right.
Okay, can I ask another question? And that is of Attorney Murphy.
Yes. Yeah, this is David Walsh. Had one,
Okay.
Mr. Murphy had mentioned that zoning, the 10.5, section 10.5 of the Board of Appeals would apply to this property. When I look at the plans, I don't think it does, because the building is more than 11 feet above mean sea level. And it specifically says, for new construction, substantial improvements to a structure to be erected on a lot 1/2 acre or less in size, continuous and surrounded on all sides by lots with existing structures constructed below 11 feet. And when I look at these plans and I look at the FEMA report, I think it's called the FEMA report, the elevation certification, both of them showing that this building is above 11 feet. Just point of reference, because I was trying to understand why he felt that was needed to come into effect here.
Would you like me to respond to that?
Certainly. Yes.
Okay. So the way I read 10.5, and then I think it is written in the conditional. The special permit granting authority may grant a special permit. I think that presumes that the ZBA is the special permit granting authority. As provided in section 9, which I believe refers to chapter 40A, and in accordance with the minimum standards of 10.4, which is the prior section. Certainly the lot is less than a 1/2 acre. And I'm not sure that, are you suggesting that a special permit, you can do anything you want in the floodplain, new construction, or a substantial improvement if it's 11 feet 1 inch? You don't need any special permit? I think that's
what it says.
I mean, that the rule says, I'm not suggesting, I'm just reading the explanation of the 10.5.
Yes,
and when I look at the plans, I can see that the front corner of the building is plus 12.4, and the other side is 11 feet 8 inches. So
yes, I understand. I think I'm trying to read 10.3, 10.4, and 10.5 so they all make sense together. If your reading is correct, it means you only need a special permit below 11 feet, but then there's really no meaningful distinction between under the 50% rule and over, because you don't need a special permit either way unless it happens to be below 11 feet. Now, that may be what was intended by the bylaw. I don't know what the practice has been, but I pointed out the need for a special permit because my reading of those three sections together would suggest that there's a consequence if you're, the reason for the 50% rule is so that you can proceed by right and you don't have to go and get a special permit. I'm not sure what other purpose it would serve. So I agree that language is ambiguous, and I don't have the plan in front of me, but I trust your reference that it is 13 feet or whatever you said above 11. 11 feet.
Okay, any further questions for either Mr. Murphy, Attorney Premison, or Mr. Wilson, who's already been speaking for us today? Peter?
One more.
Go ahead, Max. Nope, go ahead.
For Attorney Murphy, if this was a newly issued permit and not an amended permit, would you still be taking issue with it? Are you taking issue with the amendment piece? Is that what this hinges on for you, or is there more to it in that you don't think that you can like interject new permits into an ongoing matter? I'm curious your thoughts on that.
It would be a very different case if it were a new permit. I wouldn't have arguments about amending a permit that's on review in front of, at one time in front of two different courts. We wouldn't have the issue about the power to do modifications in a flood zone. And we wouldn't have, we might still have the issue of the special permit. But yes, Mr. Casper, you're absolutely right that it is a more difficult situation because a permit from 2018 was amended, 18 months later or 2 years later or whatever it was, after it had already been through this board and in front of two different judges in two different courts. So the simple answer to your question is it would not be as difficult a case if it were just a straight up new appeal. I'm not certain you'd even have an appeal if this were done as a new permit.
But to Wayne's point, issuing a new permit and amending the permit in this case, like substantively, would yield the exact same results, and that's where I am hung up on. Like, so then what is the issue? Because he could have just issued a new permit. He chose to amend it, and that's not. There's no substance to doing that one way or the other. So.
Yes. Now the issue, Mr. Premison, Attorney Premison phrased it as form over substance. That's not my argument. Is not form over substance. The substantive argument is that the prior permit, the one that got amended, was no longer valid and it couldn't have been amended. It was no longer valid. It had not been formally revoked, although a majority of this board at the last hearing I attended, I think, Mr. Casper, on your motion, did vote to revoke the permit. And had that occurred, we wouldn't be here again tonight. You only got a majority. You didn't get a super majority on your motion. But because the permit, the underlying permit, was void, it can't be amended. The simple answer would be to agree with my position and go back and do it again. And if the building inspector has all this inherent authority, he can credit Mr. Rizzo with the amount he's paid, and that may cure the problem. There's still the issue of the special permit. I don't know how to square the various provisions of 10.3 through 10.5. If the only time you need a special permit is if you're below 11 foot mean low water, then I'm not quite sure why we have the 50% rule to begin with.
So yeah, I agree with that. I don't think that's the issue to get into. But my question then is, even if we agree with you tonight, right, and we were to vote in favor of you, you agree that the petitioner, the other side, could go in tomorrow and pull a new permit for the work. So what are you trying to accomplish with this petition? Because even if you were right in this amendment argument, they can pull a new permit to do everything they're doing on this amendment. So what's the point of this?
Well, I think the point is that you've got to comply with the rules, and so there were some things that I learned tonight that I was not aware of, that are not clear from the face of the documents. For example, I was not aware that Mr. Wilson had consulted with some other expert. I thought Attorney Primison said conservation and recreation, but I don't see how that could be accurate, but consulted with some other expert about compliance with the FEMA flood code. I was not aware of that. There was a couple of other things that I was not aware of, but if the permit was invalid, which was our contention under the request for enforcement, then it can't be amended. You got to do a new one. And, you know, I guess I would rephrase the same question the opposite way, is if in fact we're correct, what's the harm to just asking Mr. Rizzo or Mr. Wilson to issue a new clean building permit?
Does this then is the end game? So we issue, or we go through this and Mr. Wilson issues a new permit. Does this then go away? Like this is your one bone of contention, is that Mr. Wilson may, or in your eyes, have stepped outside of his boundaries to amend a permit when maybe he should have issued a new one? Is that what you're
Mr. Barber,
contending?
No, there's other issues that are before the court that I alluded to, and I'm happy to discuss them. The property is a non-conforming lot in almost every way except height. The side setbacks, frontage, it's undersized lot, it's over the coverage. And so I think my contention in court and possibly before the board the last time, a year ago, was that a special permit is required under Section 6 because it's an extension of a nonconformity. The position was that this board agreed with that and initially denied the special permit. Then it came back for a revised application, which, by the way, was not repetitive because the applicant decided to take down the garage. The problem with that is that also required a special permit. And if you give me just a second, I can find the bylaw provision that refers to that.
I mean,
Mr. If I could just kind of settle things here, because what you're referring to is not exactly correct. For example, when I don't want to get into the history to that degree because we're here to discuss a certain issues tonight, and we're going to be here till midnight if we take that approach. The prior decisions are on record, and there initially was a decision where involving the porch, and we at that point in time denied the relief requested by the Rizzos. So I'm not sure why, I don't know if we need to get back into that particular decision again tonight. Peter, did your question get answered?
Yeah, I mean, I go back to the, I think the other attorney, when he first started, he basically said that they're looking to comply. I mean, the problem is that, he started off with a project, he changed his mind, he increased his project, now he's complying with FEMA. And I don't understand what the end game is. Is it simply because the permit didn't get filed properly?
That's a good question. Attorney Murphy, how is it that you feel this property doesn't comply with FEMA regulations?
Well,
Or the floodplain regulations?
yeah, so the property is non-compliant in that it's an undersized lot. It has less area than is required. It's grandfathered because it was built before that zoning. It also has insufficient frontage. It's excessive lot coverage. And incidentally, the section that speaks to that is 7.03E that says, notwithstanding other requirements of 703, no structure located on a non-conforming lot may be removed and replaced elsewhere on the lot. So the reason that the removal of the garage doesn't cure it is because that's just one of several zoning.
That doesn't answer the issue of it has nothing to do with the floodplain regulation. How are you determining that this property is not in compliance with the flood regulations? You're talking about your position that the property is non-conforming. We're all aware of your position on that because you've been before us before, and respectfully appreciate your position. And we had decided against that because of the fact that the Bellata case came out and we determined that there were no new non-conformities on the property. But now you're saying that is the reason why it doesn't comply with the floodplain? I just need to understand that.
Oh, let me just be very clear. If a special permit is required under any provision of the bylaw, whether it's the floodplain or non-conforming lots, then you have to have that special permit before you can have a building permit, whether it's a brand new one or an amended one. So I think that same issue is present today. The issue with the floodplain in particular is my reading of section 10.5, which represents 10.4 and 10.3. For those sections to make any meaning, if you're going to do a substantial improvement or new construction, you've got to have a special permit. I realize the language does make reference to 11 feet, and I accept that the plan says that it's above that, but that's a very, I think a very restrictive reading of the bylaw, because then it doesn't make sense. If you're in the floodplain, then you can just pull a building permit for a substantial improvement or new construction, just like you could for the 50% rule. And then what is the purpose of the 50% rule? It actually serves no purpose whatsoever.
Okay, I appreciate your answer. Anyone else have any questions for Attorney Murphy or Attorney Primerson? No? Okay, at this point in the hearing, I'm going to ask if there's anyone present. I want to make sure I unmute people in case they want to speak. Is there anyone here who would like to speak in favor or in opposition to the application? And I'll take those who would like to speak in favor first. And if you're going to speak, please state your full name and your address. Make sure you're unmuted.
Robert Rizzo, 96 Willow Road. I'm the owner and I'm in favor.
Mr. Rizzo, I think you'd be on the, well, I'm going to take anybody who wants to speak in favor first, so give me a minute. In favor of the request for enforcement. Anyone else here who would like to speak in favor? Make sure I tried to unmute everybody, but they keep muting themselves. I think that means because they don't want to speak. You have to assume. Okay, so nobody has actually asked to speak, getting any chats or anything. Okay, is there anyone who would like to speak in opposition of the applicant's request for enforcement?
Robert Rizzo, 96 Willow Road, and I oppose Paul Smith and Judith Flattery's petition.
Okay. Okay, now that we have heard from the members of the public, we're going to go into our deliberations. And if everybody could just kind of stand by and let us do our discussion. And if we have any questions, we'll ask you. We ask that you not interrupt us. Okay, so the issue before us tonight. What does everybody think? What does everybody add?
I guess we need to talk about what findings do we need to vote on in order to deal with the Enforcement Act.
Okay, so I think what we should probably do is come to a consensus really about these findings. I'm going to make some suggestions and then we can decide which way to go with each one. I think that we need to make a finding really whether or not the question here really was whether the amended permit is valid, but prior to that, whether the property was in compliance with that 10.4. And if it is, then there's no need to go to 10.5 in our zoning bylaws. It's one of the ideas. Another one would be whether we're going to affirm or deny the building inspector's or revoke the building inspector's determination in this matter.
All right, so we probably deal with the building inspector's decision first.
Well, first, I think we should. Do you want to talk about the compliance first to see whether the property was in compliance? Then that will help us to make that decision.
Okay.
Does everybody have section 10 of the zoning bylaws that I did send to everyone? I made sure that Kim sent out a most recent copy of the zoning bylaws.
Yeah.
Okay. So if we look at 10.4, for example, there are 5 sections here. And the first one involves the state building code. 2, 3, and 4 involve wetlands, and number 5 involves Title 5, which is septic. So 2, 3, and 4, we all have copies of the orders of conditions, which state that the wetlands don't apply. Does everybody agree with that?
Correct.
Yes. And then, so really good. And obviously, we have town sewer. So the section that we probably need to consider is number 1, which is whether it's compliant with the state building code regarding floodplain and coastal high areas, maybe. And if we take a look at that.
Which section are you looking at right now?
10.4.
10.4?
10.4.
All right.
Yeah. So, I mean, it looks like 1 and 4, right? Wetlands, the coastal wetlands restriction. I mean,
1 would apply. 2, 3,
right. And
we have the Concom orders of conditions everybody should have that
right.
state that wetlands are not applicable to the property.
Right.
So.
And does that include coastal wetlands?
She doesn't say. She says wetlands.
Okay, so it didn't. But at this point, they're complying with the Concom, requirements, and according to Wayne, and he did consult somebody that the Rizzos are complying with section 10.4, section 1, which is the building codes where it addressed floodplain, correct?
I believe that was his testimony. If you want to ask him again, Mr. Wilson's still with us. Thankfully, we can ask him.
Yeah, Wayne, right? You're attesting to that?
Yes.
Okay, great. Thank you.
But no one has even said anything to the contrary. I haven't heard anyone make a case that it's not, that the new amended permit is not consistent with the building code. I felt like his argument over 10.4 is that he's basically saying that any substantial improvement requires a special permit. And I see how he's reading into that, but I don't agree with that conclusion. That'd be a major decision, that anytime someone does a substantial improvement on a house in the flood zone, they need to first come to the zoning board. I don't think this section 10 is well drafted. I should say that first off, so I can understand why people are reading different things out of it. It's not very good, but I don't think that the intention is that any substantial improvement comes to the zoning board for approval. So that I don't think it's about is this compliant, because no one has said that they're not meeting the substantial renovation, substantial improvement sections of the building code. Right? Nobody made the argument.
Right. So essentially, what I guess they're saying is there should have been a special permit issued first, because they're doing a substantial amount of work to a house, right? And I'm looking over and I see Mr. Murphy shaking his head. So that's what they're saying, is we're required to have a special permit, or I should say the Rizzos are required to have a special permit because they're doing substantial work to a property that happens to have a small section of the front lawn in the flood zone.
No, he also said that I think that it's ambiguous and it's not clear that that's the case, but that's his reading of it. But I don't agree that that's the intent of the bylaw, for every substantial improvement to get a special permit from the zoning board. That's not what I'm reading it as.
I think we'd be meeting every night of the year if that were the case.
All right, so the question is, were that to be true, then would we be putting the cart before the horse if we decided to grant a special permit?
No one's seeking a special permit. We can't grant a special permit.
We can't anyways.
No one's requested it.
It hasn't been applied for.
Okay. But isn't that what Mr. Murphy is saying, that there should be a special permit, that it is a petition?
Well, that's how they're reading. That's how they're reading 10.4, 10.5.
Okay, that's what I'm just asking.
Zoom meeting.
What's that?
But that's not how I'm reading it, and it sounds like that's not how Max is reading it. So the question becomes, how are others on our board reading it? If we understand it to not mean that there should be a special permit, then we find that, our finding is we disagree that a special permit is needed.
Well, I'm agreeing that we don't need a special permit. That's why I brought it up originally.
So does anyone feel that a substantial improvement in the flood zone on its own, that being the only issue, requires a special permit? Does anyone feel that way, Jocelyn?
No, I don't.
Okay.
I don't either. So is that our finding?
Well, I think that's I think we should make a finding as to that. That would be helpful to the ultimate decision.
All right, I'll make a motion that we have made a finding that the sections 10.4 and 10.5 of the zoning bylaw does not require a special permit for every project that's every substantial project in the flood zone. Does that sound right?
I would tailor it to this particular project, and instead of being so broad, that's all. In other words, you're looking at this particular project and saying that it doesn't require it.
Yeah, but it's neither here nor there. The finding is that section 10.3 and 10.4 and 10.5 do not say that, whether it's this project or any project, this doesn't say that we're required to have a special permit.
I think that's a good basic finding to start with.
Yeah, I don't think, if we start talking about this specific project, Dave, then we're kind of honing in on this project. The idea is that we right now are in agreement, or at least I'm making a motion that we're in agreement that 10.4 and 10.5 does not mean that for every substantial project in a flood hazard area requires a special permit.
Okay, I'll second that motion.
Okay.
Okay, any discussion on the motion amongst the members?
Dave McCool here. I mean, I agree, like 10.5, because of the elevation certification that was submitted, I don't believe it doesn't require it under 10.5. I mean, if there's back to 7.3, I couldn't really find where this project would require a special permit. But I mean, under 10.5, because of that elevation certification, it brings it out of the requirement for the special permit.
Okay. Attorney Script, do you want to add anything to our discussion on that motion?
Yeah, let's look at the bigger picture here. 10.4, and let's take a house all by itself. Say it's all by itself on Willow Road, nothing's around it, and it's in the floodplain district. Well, 10.4, what it says is, okay, well, you have to make, if you're going to make a substantial improvement as defined by other regulations, then you've got to come into compliance with 10.4. And 10.4 just basically requires that you comply with the floodplain regulations, that eventually came from FEMA, then trickled down to the state building code. Okay, so now take that same house and put it on a small lot and put small lots all around it. Now you can see how they're exacerbating the problem in that now you have a bunch of small houses on small lots. That's what takes you to 10.5. That's what takes you to 10.5 requiring, okay, now you have to go an extra level, because now not only is a flood going to damage your home, it's going to damage homes around you as well. So in that particular case, and as Dave Walsh mentioned earlier, he's honing in on the language at the end of the first paragraph, talking about not only about construction below 11 feet above the mean sea level, but if you look a bit before that, it also talks about small lots and all of the lots around the particular lot being small lots, okay? And all they're saying is, hey, listen, if this comes to pass, you have to go this extra level to help protect everything around you. And in this particular case, I haven't heard any evidence of there being small lots, not only for the subject lot, but surrounded by on all sides by lots with existing structures below that route. I've not heard any evidence of that. So I think you guys are going in the right direction.
All right, so we already discussed this motion. All in favor, let's take a roll call vote for that motion, please.
Peter Barber says aye.
David Walsh says aye.
David McCool, aye.
Max, I did hear you. Did you respond?
Aye.
And
Aye.
Jocelyn Campbell, the chair, says aye. Okay, so we've made that preliminary finding regarding whether or not a special permit is required. And so at this point in time, we're saying that no, we don't believe a special permit is required. Do we need to make any more findings, such as the, as far as this amended permit is concerned?
Well, in having questioned two current building inspectors, both responded by saying, and lawyers, but all responded by saying there's nothing in Mass Code or zoning bylaws that basically says a building inspector can't amend a building permit. So that would be a finding.
I agree, Madam Chair. That would be a finding that would be helpful if and when this goes to appeal.
So Mr. Barber, did you have a particular, do you want to word that? Or?
Yeah, let me think about it for a second. I'll make a motion that on the information provided by two current building inspectors and three attorneys, that a building inspector does have the ability to amend a permit.
I'll second that, David Walsh.
Any discussion on the motion? All in favor? Roll call vote, please.
Peter Barber says aye.
David Walsh, aye.
David McCool, aye.
Max Casper, aye.
Justin Campbell, aye. Okay, so we've now made two findings. One is that we decided that no special permit under 10.4 or 10.5 is required for an amended permit. And then we have made a finding that the building, Peter, could you read that back to me? Building inspectors.
The last motion,
Yes.
it was that on the information provided by 2 existing building inspectors and 3 attorneys, that building inspector can amend a building permit.
Amend the permit. Okay, so we've gone that far. And the question before us tonight is the appeal of the building inspector allowing a building permit R18-00243 to be amended and the issuance and validity of the amended permit.
So, Jocelyn, there's, I think there's a third prong to the attorney's argument that is the most interesting, and that's, how much can continue to be applied for and permits be issued to a property when it's already sort of under multiple appeals? Is there a limit to when things need to pause, right, at a property so that the issues that are being worked out can be worked out? Otherwise, are we just going to be continually peppered with new permits, new appeals, and is it ever gonna end? So, I mean, I think it's partly our own doing by not revoking the permit originally and then just letting it get reissued, because that would have been cleaner. I'm not saying that it's not okay to have amended it, but it definitely would have been cleaner to just issue a new permit. But I know, like, maybe in the future for best practices, Marblehead has language in a lot of their decisions where they like put a hold on permits being issued at a property while things are being sorted out. And I'm not aware of anything sort of like in foyer or in our bylaw that says we need to put a pause on things. So, but at the same time, I understand the desire to like not have other projects that are very similar to the projects that are being judicially reviewed kind of continue. So, I mean, I think ultimately where I come down on it is that there's nothing that says you can't amend this permit that I can see, and there's nothing that says that like other subtly changed projects can't proceed. But there is at least some merit in the argument that like where does it stop? When do things sort of hit pause at a controversial property so that the issues can be worked out and then it moves on from there? But I just don't know that sort of pause that I'm describing is mandated anywhere, or that having us not put it in place previously, we can read it in at this point. So that's my feelings on it.
I think you're onto something, Max, because in hindsight, would have been not had we didn't know all this was going to go on, right? But we also, we just didn't know what was going to happen. But maybe when we have our next annual meeting, we can talk about with our rules and things like that, what we want to change. That might be a good point to talk about it. You know what I mean? But right now, the position where we have we didn't, pause anything. And again, I don't know if like what's the difference whether he gets a new or he amends. Again, like we've said during this, I've heard people say tonight, I'm not sure that's going to make any difference today. That's an interesting point. Did you have a motion or anything? You just wanted to make that point?
Well, I guess, I wanted to open that up a little, like get people's thoughts on it. Is there anything I mean, I'm leaning towards it's okay to amend this permit. It's a little confusing in the mess of it all, but does anyone feel as though that it's problematic for work to continue at a controversial property while other issues are being resolved? I guess.
Just want to quickly, because I think that one of the things I would say is, well, how can this person come into compliance if we don't let them amend and put their property into compliance? How would we do that?
Madam Chair, I can help out with this.
If you'd like to chime in, you're welcome to.
Yeah, well, starting with your point, and it's a good one, it's that I don't know any judge in the Commonwealth that wouldn't be happy to have one less case on her docket. And resolution is the way these cases go away without actual trials. And this is one avenue of resolution. So to the extent the parties are arguing, or at least the complainants are arguing, that you can't amend the complaint to cure defects that they brought up, it's just not logical to me. But more to Max's point, and where does it stop? There's nothing in our bylaws or the Board of Appeals rules and regulations that prevent it. In this particular case, if Attorney Murphy or Mr. Smith were unhappy with the issuance or the potential issuance of a new another amended permit, they could go to Judge Barrett in Essex Superior and look for an injunction against any more amendments to this permit. They have that power. And Judge Barrett has the power to say, okay, that's it. We're sticking with the permits that are issued now. No new amendments or no new permits until I give the go ahead, I being the judge. So that's how it could be handled in this particular case. In the future, as the chair mentioned, you could consider more changes to the rules and regulations. But as of now, there's nothing stopping the complainants from going to the Essex Superior Court and seeking some form of an order, which I would think they'd be hard pressed to get, but they can ask for it.
Thanks for your input.
But that's wait a minute, but that's in order to put a stop on permits and new permits or amended permits. The problem is they already have an amended permit to basically take them through the entire project. I mean, right. Unless they decide to change something.
That's what I'm getting at. Something in the future.
I mean, right. I think to Max's point is, here we have a situation where I think there's still 2 outstanding lawsuits. I don't know what they.
Well, actually, there's one as of today.
Oh, okay. There's one outstanding lawsuit. I'm not sure exactly what that one pertains to, but here you have a project where you have this lawsuit, and at the end of the day, if when the lawsuit kind of calms down, it could be well after the fact that Mr. Rizzo has completed his project. So, Max, was your point like a cease and desist from a court order, or?
No, I'm not. I was just seeing if anyone had any concerns about that, but I'm not hearing any. I'm not concerned of it to the point of saying that we need to vote favorably to this petition. I just wanted to make sure no one else shared that sort of avenue of concern.
I mean, when I ask the question, what's the end game here? I don't see what the end game is. I mean, we have a person that's doing a major renovation on their house. They tried to, or they changed their plan, and they ended up having to go and do 100% compliance. They are now moving in that direction, or building in that direction, I should say, and we'll have 100% compliant house when they're completed. So I don't understand, I still don't understand why we're still here discussing it. I want to say, I don't want to say it's semantics, but it's a new permit versus, maybe a new permit would have made it more clean and easier, but the building inspector, at least from what I understand, under his purview, is able to amend a permit, and that's how he chose to do it, instead of, here, go fill out this form, come back, hand me the same check, hand me all of the same plans, and that's what he chose to do. And I think the homeowner is going to comply, So I don't know what the end game is at this point.
You know, I'd like to ask a question if I could, Dennis.
Oh, go ahead, Dave.
Without opening up Pandora's box and not dragging this on for another 20 minutes, what is your client's wish?
I think it's
ultimate wish.
I think it's to see that the renovations done next door are in conformance with the code to protect their property. So I view it as good news that among the changes that there's going to be, you know, they call them, Mr. Wilson called them holes for if the water flows through. You know, I don't have the sophistication to notice every little thing on the plan, but that kind of thing that the abutters consider to be good news, because whether it's holes or breakaway panels or something that makes it so that their properties are protected, that's really their interest.
Okay, thank you.
Thank you.
Such a liar.
So are there other, do we need to do another, do we have another decision to make at this point, Jocelyn?
I think we do. I think we need to make a finding concerning, first of all, you know, there's been a lot of discussion about non-conformities. There's been some discussion about that. There's been discussion about the special permit. We've already talked about that. The idea that a special permit might be required, but we determined that it was not. And we've also determined that the building inspector has the right to amend the permit. And I think that we should probably make two findings here. It depends on everybody's consensus. One is that we're not seeing any new nonconformities here from previously. And two, that we either affirm or deny or revoke the building inspector's determination.
So why the finding about the new nonconformities? Why?
Well, maybe we don't need to make a motion about that. It's just an idea. I don't know. We could go just right for the affirm or deny, in my opinion. You're right.
Max, I can answer you in that one, if you want to give me a moment, Madam Chair.
Okay.
Because we don't even have plans in front of us that we're reviewing for conformity or nonconformity. But go ahead, Ben.
Well, Attorney Murphy made nonconformities one of his 3 or 4 points, so I think we should at least mention that no evidence was offered showing that the new plans have delivered you new nonconformities. I think that would help me on appeal when I'm standing in front of Judge Barrett explaining your decision.
All right. So we make a finding that no new evidence was presented that would indicate that there was any more non-compliance with the plans.
The amended plans.
Amended plans.
Yeah.
Thank you. Dave, you're on mute.
That's stopped. I like that language is fine. Okay.
I'll second that motion.
Okay. David Walsh has seconded the motion. Is there any discussion on that motion? All in favor of the motion? Roll call, please.
Peter Barber says aye.
David Walsh, aye.
David McCool, aye.
Max Casper, aye.
Jocelyn Campbell, aye. Okay, so we just have really one motion left. And anyone want to bring a further motion?
I'll make a motion that we deny the petitioner's application for requesting. I'm sorry, I don't have the language here.
The RFE, you mean? Request for enforcement.
Deny it's not a request. What is it? It's a
RFE, request for enforcement.
Yeah. Request for enforcement.
An appeal of the building inspector's allowance of the building permit. So we would, if it sounds like we're going to be in favor, we would say we're going to affirm his denial. And if we're going to not be in favor, we would reverse that. So-
No, Josh, I think you got a little backwards.
No, you got it backwards.
I got it
Yeah,
backwards.
the
We don't
Okay,
want to
it's
affirm.
late. I found it. All right.
Yeah.
So do we have a motion from someone? Peter,
Yeah, Max,
Um,
Max?
why don't you repeat
You
what you
want to
said?
take another stab at it?
All right. I make a motion that we deny the petitioner's appeal of the building inspector's issuance of an amended building permit.
I'll second that motion, David Walsh.
Any discussion on the motion?
I think based on the findings that we've come up with, the reasons why, we shouldn't.
All in favor, roll call, please.
Peter Barber says aye.
David Walsh, aye.
David McCool, aye.
Max Casper, aye.
Jocelyn Campbell, aye. Okay. Is there any other motions that we need to bring tonight?
I don't think,
Madam Chair,
Dan,
I'll
do we
just-
have to do any more?
Make
Well, in
a
essence,
note.
by denying the appeal, we are affirming the building inspector's decision.
Correct.
Is that fair to say?
That's correct.
All right.
Madam Chair, one note, point of order, if you don't mind.
Sure.
Shoot.
In the deliberations, just make clear that the previous finding the ZBA made in September 2019 pertaining to the repetitiveness of the first half of complainant's petition will be in the decision that is eventually issued after today's hearing. That's all. It's not a motion, it's just to get that on the record to make sure it's clear.
Okay, should we have a motion for that, Attorney Smith?
No, it's just in case, it'll be in the minutes. And so everyone listening to this hearing understand that that will be part of any basis of appeal that Attorney Murphy might want to take.
Okay. Do we need to incorporate that in terms of a vote or no?
No, the vote's already
No?
made. It's already fine. It's in minutes already produced.
All right. So if that's that, then I think we're at the end of our hearing tonight, and it is now 7:05 p.m. And do I have a motion to adjourn?
I'll make
Yes.
that motion.
Wait a minute, before we adjourn, almost forgot.
Make a motion to adjourn.
I'll
We
second the
have to let
motion.
the petitioner know that there's a 20-day period of appeal after the decision is filed with the clerk. And your appeal can be to the Superior Court or the Land Court, but may be filed in the District Court according to the actual rules. So motion to adjourn, please, was by
Yes,
Yes,
Peter
I
Barber.
seconded it.
Peter Barber, seconded by David Walsh.
Yep.
Any discussion on the motion? All in favor, roll call, please.
Peter Barber says aye.
David Walsh, aye.
David McCool, aye.
Max Casper, aye.
Jocelyn Campbell, aye. Thank you, everyone, for your hard work.
Thank you.
Thanks,
Thank you all.
Jocelyn.
Merry Christmas to everyone.
Merry Christmas, happy holidays.
I can say that, it's not part of the meeting.
Right.